Islam, peace, love, and energy. I am Sade Renee L, all rights reserved, and I'm back at it again with another video. And today I'm actually going to be reading a snippet out of this book called A Dissertation to Personal Property by Honorable Anaidah L. Great book, goes over the basics, foundations, from top to bottom. It's a quick read. I recommend you get you a copy if you haven't done so already and read it. But for now, I'm going to be taking a little clip out of the book in regards to de facto acting as judges. And with that being said, please like, share, subscribe, leave a positive comment, and I'm going to read it straight through. Read it as follows. And it states, what is the status of a judge? Sure versus Rhodes. Note, by law, a judge is a state officer. The judge then acts not as a judge, but as a private individual in his person. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction and the judge's orders are not voidable, but void and of no legal force or effect. The U.S. Supreme Court stated when a state officer acts under a state law in a manner violated of the federal Constitution, he comes into conflict with the superior authority of that Constitution. And he is, in that case, stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Did you know that under Title 8 U.S.C. 1481, when a judge takes an oath of office and undertaking, that he gives up his citizenship and therefore has no immunity to prosecution? Why would the judge lose his citizenship? Good question. Answer. Most judges are also members of the Bar Association, which has its headquarters in the United Kingdom in violation of the United States Republic Constitution, Article 1, Section 10. Below is the complete title code reference above for our review. Title 8, Chapter 12, Subchapter 3, Part 3, 1481. Loss of nationality by native-born or naturalized citizen, voluntary action, burden of proof, presumptions. A person who is a national of the United States, whether by birth or naturalization, shall lose his nationality by voluntarily performing any of the following acts with the intention of relinquishing his United States nationality. 1, obtaining naturalization in a foreign state upon his own application or upon an application filed by a duly authorized agent or upon an application filed by a duly authorized agent after having attained the age of 18 years, or 2, taking the oath or making an affirmation or other formal declaration of allegiance to a foreign state or a political subdivision thereof after having attained the age of 18 years, or 3, entering or serving in the armed forces of a foreign state if A, such armed forces are engaged in hostilities against the United States, or B, such persons serve as a commissioned or non-commissioned officer, or 4A, accepting, serving in, or performing the duties of any office, post, or employment under the government of a foreign state or a political subdivision thereof after attaining the age of 18 years, if he has or acquires the nationality of such foreign state. Or, flip the page, here we are, we're at B. Or, accepting, serving in, or performing the duties of any office, post, or employment under the government, foreign state, or a political subdivision thereof. after attaining the age of 18 years, for which office, post, or employment an oath, affirmation, or declaration of allegiance is required. Or 5, making a formal renunciation of nationality before a diplomatic or consular officer of the United States in a foreign state in such form as may be prescribed by the Secretary of State. Or 6, making the United States a formal written renunciation of nationality in such form as may be prescribed by and before such officer as may be designated by the Attorney General. Whenever the United States shall be in a state of war, and the Attorney General shall approve such renunciation as not contrary to the interest of the national defense. Or 7, committing any act of treason against or attempting by force to overthrow or bearing arms against the United States, violating or conspiring to violate any of the provisions of Section 2383 of Title 18, or willfully performing any act in violation of Section 2385 of Title 18, or violating Section 2384 of Title 18 by engaging in a conspiracy to overthrow, put down, or to destroy by force the government of the United States, or to levy war against them, if and when he is convicted thereof by a court martial or by a court of competent jurisdiction. B, whenever the loss of the United States nationality is put in issue in any action or proceeding commenced on or after September 26, 1961, under or by virtue of the provisions of this chapter or any act, the burden shall be upon the person or party claiming that such loss occurred to establish such claim by a preponderance of evidence. Any person who commits or performs or who has committed or performed any act of expiration under the provisions of this chapter or any other shall be presumed to have done so voluntarily, but such presumption may be rebutted upon a showing by a preponderance of evidence the act or acts committed or performed were not done voluntarily. And I'll flip you guys to that page, scroll up one. Here we are. Okay. Often, a judge presumes to enter a plea for you acting under unsolicited power of attorney. Okay. As well, he acts as a prosecutor and he practices law from the bench. Facts. It is the prosecutor or the complainant that must present the case. It's common sense, right? Not the judge. He is to be a neutral party. Once again, common sense. The referee that keeps all proceedings within the bounds of law as required by law. If you find yourself in a courtroom or a tribunal going back and forth with the judge, then he is clearly in violation of practicing law over the bench, or he may be acting as an unsolicited power of attorney, and grounds for recusal are evident. That's evident. Title 28, Part 1, Chapter 21, 454, Practice of Law by Justices and Judges. Any justice or judge appointed under the authority of the United States who engages in the practice of law is guilty of a high misdemeanor. If he is in violation of his oath, he has committed treason. Penalty of perjury. Perjury is usually understood as lying while under oath. However, That is not quite right. The original meaning was a violation of one's oath or affirmation. The word perjury is usually defined today as a lying under oath about a material matter, but that is not its original or complete meaning, which is violation of oath. We can see this by consulting the original Latin from which the term comes. An Elementary Latin Dictionary by Charlton T. Lewis, 1895. Note that the letter J is the letter I in Latin. All right, and I can't see that too good, so I'm going to flip right here. Puririum, false oath, perjury. Purius, adjective, oath breaking, false to vows, purged. Iro aviatus are, to swear, to take an oath. Irator, oris, a swearer. Iritus, adjective, sworn under oath, bound by oath. Isis iris, that which is binding, right, justice, duty. Per, for, of means or manner. Through, by means of, under pretense of, by the pretext of. All right, next page. All government officials are bound by oath in all matters until they leave office. No additional oath is needed to bind them to tell the truth in anything they say, as telling the truth is pursuant to all matters. All matters. Any public statement is perjury if it is a lie and not necessary to deceive an enemy. A government official does not need to take a special oath to become subject to the penalties of perjury. They took an oath to faithfully execute their office and to preserve, protect, and defend the Constitution of the United States to the best of their ability. While they hold that office, they are always under oath, always under oath. And lying at any time constitutes perjury as well as treason. Treason is a violation of the United States Republic Constitution, Article 2, Section 4, and Article 3, Section 3, supported by the following United States Code. Title 18, Part 1, Chapter 115, 2381, treason. Whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid or comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000 and shall be incapable of holding any office of the United States. In 1950, 81st Congress investigated the Lawyer's Guide and determined that the Bar Association is founded and ran by communists under definition. Thus, any elected official that is a member of the bar will only be loyal to the bar and not the people. All judges from courts with no jurisdiction are nullities. We got Basso versus UPL, we have Brook versus Yaki, and we have Elliott versus Pearsall. Under federal law, which is applicable to all states, the US Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. They're not voidable, but simply void, and form no bar to a recovery sought even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as well as trespassers. Yep. And that's the read that I have for now. Thank you for tuning in. Once again, please like, share, subscribe. I actually want to go over some more information in this book, so check me out because I'll be back with another video. Also need to do a video on the update in regards to baby Ashe. A lot of stuff has been going on in regards to me continuously fighting for my baby to be safe home with her mother. Okay, the person who birthed her, like natural birthright, and not to, you know, have genocide to my family as far as she's with this lady named Sarah, who is a European lady. And I'm quite sure our cultures, practices, and beliefs are quite different. I don't think she studies the star as far as love, truth, peace, justice, and freedom. Because if she did, she wouldn't want to adopt or even be a part of the kidnapping with my child. Anybody who has that type of love should know that if a mother's fighting for their child back, then why would you want to try to adopt them? Why would you want to stop that? Just make it make sense. So yeah, I'll definitely update you guys with that. It's going to be a long, lengthy video because I want to tell you guys everything kind of like from top to bottom and let you know what's going on right now, as far as all the documents, all the fighting that I've been doing lately, all the de facto clerks that are refusing to file my paperwork, fraud. And that's where the people come in, we the people. So once again, please feel free to like, share, subscribe, tune in for my next video. Thank you for your energy, energy, energy. Ashe will be home soon, so mote it be. It is ordered. It is by divine law and by divine right. And I can feel it. I can see it too. So that's the main thing. I can see it. I can't see it with these two eyes, but I can see it with my eyes overall. And that's what matters. You got to use your imagination. Yes, indeed. Well, again, thanks for tuning in. Peace and love. Pax et amor. Until next time. Islam.